Once we go live.
I think we're live.
We are live.
Yeah, we're live.
Good afternoon, ladies and gentlemen. Good morning, good evening, wherever you may be listening to our podcast. This is Dr. Olu Asekun here. What?
On that side.
This one? Okay, thank you. Can you please? Yeah. Okay. Welcome to our podcast. This is another edition of Dr. Olu Asekun podcast. Wherever you may be listening, please invite your friends, family, colleagues at work to join us. Today, we have a lot of updates before we go into questions and answers. So, we have a lot to talk about today. Remember to invite your friends, family, and well-wishers to join us. As you know, we provide a whole lot of information on this program, and it will be unfair for you to keep all this information to yourself. Let others benefit from it as well. We do this free of charge, so it is imperative that you let others benefit. It doesn't matter whether you are a U.S. citizen, you are a permanent resident, you are not even an American, you have nothing to do with the United States. You may have somebody who may be interested in this information, and you may also have people this information may be useful for. So that is why we implore you to invite members of your family, your friends, circle, to be part of this podcast. So today, we are starting with the updates as usual. And like I said, there are so many updates between last week and now. Even though I was not around last week, I believe that our team did a diligent work, and I also joined over the phone. So today, the first update we'll be talking about, as provided to us by American Immigration Lawyers Association, is that USCIS report uncovers major abuse in the SIJ program. According to the American Immigration Lawyers Association, USCIS released information that over 300,000 SIJ petitions filed between 2013 and February 2025 were reviewed. More than half filed in 2024 were over the age of 18, and many of these applications were fraudulent. There were so many age falsifications, there were date of birth falsifications, and there were plainly identity fraud. And this is one of the reasons why the deferred action for SIJ was rescinded in June. For those who listen to us regularly, you recall that in June we did mention that the SIJ deferred action was cancelled, was rescinded. This is one of the reasons. For those who may be wondering what is SIJ, it is one of those pathways that children can obtain permanent residency and subsequently U.S. citizenship. In order for somebody to be eligible for SIJ, SIJ simply means Special Immigrant Juvenile. The applicant must be under the age of 21 at the time the application, at the time the court order was obtained. For somebody to be eligible for SIJ, there must be a state court in the United States who have made a determination that it is in the best interest of that child to not go back to his or her parent, either because this child has been abused, neglected, or in other ways harmed. So the first step for somebody to file an SIJ petition is to apply to a state court, either the state district court or a state county court, and then present a petition, and they will have to show to the court, demonstrate to the court that, look, this child who is under 21, it will not be in his or her best interest for the child to go back to his or her home country or to go back to his or her parents because either the child has been abused, either the child has been neglected, or either the child has been maybe there are some mental issue regarding the child. So at the end of the day, what the court is going to look at is the best interest of that child. So if the court found that this child has actually been abused, the court will make an order that the child should stay with the applicant, whoever the petitioner, whoever files the petition in court, usually a U.S. citizen. So once this petition is approved, the applicant will now use this state court order to apply for permanent residence for this child under the SIJ program. But what immigration uncovered was that a lot of fraud was going on with this program. Some of these applicants, they have to forge their age. Some, they had to give them a fake name. All kinds of fraudulent activities was recently discovered by the immigration. This is very sad because the problem here is that a lot of innocent children now are going to suffer the consequence of this fraud. A lot of innocent children, because now a lot of SIJ petitions, even legitimate SIJ petitions, may suffer denials because of this fraud. I remember in 2009, similar exercise was carried out regarding the religious petition. And at that time, about 1/3 of the selected petitions turned out to be fraud. That was what led to the site inspection instituted by immigration since that time. That is why for any religious organization to file a petition today, they have to show documentary evidence that they can afford the salary. They have to show pictures of the religious organization inside and outside. And immigration has to conduct a site inspection of the religious organization. So the problem is by our actions, we keep making immigration difficult, more and more difficult for innocent people with all these fraudulent activities. But, well, it is what it is. So that is one of the new developments that was released to us last week. Now, the next update, you will recall that I mentioned that American Immigration Lawyers Association and American Immigration Council, they filed a lawsuit regarding green card. I think we mentioned this last week. Okay, so I'm going to skip that. Okay. The next one I'm going to be talking about is that effective September 28, 2025, that is next month, all applicants who do not speak or understand English must bring their own interpreters to interviews. So if an applicant does not bring interpreter to the interview will be rescheduled, or the interview may be canceled after 2 rescheduled attempts. Immigration has made it clear that they will only reschedule interview not more than twice. So if you are not able to speak English, it doesn't matter the type of application you have pending. If your application requires an interview and you know you cannot speak English, please go to the immigration office with your own interpreter. In the past, at least currently, because this new rule is going to be effective next month, September 28 to be precise. In the past, if you go to immigration office without an interpreter, the officer will have to call, they have this line of translators, interpreters, so they will call them and put them on the phone, swear their in, and then they will conduct the interview. Or in some cases, If the officer knows of any other officer within the building who speaks the applicant's language, they can request assistance. And in some cases, especially in the case of Spanish, a lot of officers speak Spanish, so they will still go ahead with the interview. But under the new policy, if your case requires translation, they are saying that USCIS will no longer provide interpretation services. So you have to come with your own interpreter. So, but this is going to be effective September 28, 2025. And it is important that you circulate this information because the maximum time an interview can be rescheduled will be twice. So if you don't know about this and you go to immigration office for interview and they reschedule it because you didn't come with an interpreter, that means you will have only one more chance at rescheduling. So the maximum time they can reschedule interview because of interpreter is twice. That is the maximum. So it is very important. If you know you don't speak English, go with your own interpreter. Now, the next thing we want to talk about, the next update, is that the DHS, that is Department of Homeland Security, they have quietly ended the deferred action for labor enforcement program. Labor enforcement program, this program was put in place by the Biden administration. So it was to protect undocumented workers who are being exploited. So under the program, undocumented workers who are being exploited, they had the option of reporting the exploitation, and then they can use that as the basis for applying for employment authorization and legal status. But DHS did not announce this. They didn't announce it. They didn't do anything. They just quietly ended the program. So as of today, the program has been stopped. Yes, yet there was no DHS announcement. There was no announcement anywhere about it, but yet they have stopped the program. So, but of course, because American Immigration Lawyers Association, they monitor all these things, so they are able to discover that DHS has quietly ended this program. The next thing that I want to talk about, the next update, is that and this is a major one. This is a major one. The Department of State, remember, all the U.S. embassies all over the world, they are under the Department of State, the United States Department of State. They are the one that controls the U.S. embassy. So now the Department of State issued a temporary final rule establishing a 12-month visa bond pilot program for visitors, B1, B2 applicants from certain countries. Now, this pilot program requires that visa applicants must post a maintenance of status and departure bond. This bond are in three categories: $5,000, $10,000, and $15,000. The $10,000 is the standard. However, for certain applicants, the consular officer may reduce it to $5,000. And for certain applicants, if the consular officer believes that the $10,000 will not deter the applicant from going back to his or her own country, the consular officer can increase the bond to $15,000. Now, the consular officer has a lot of discretion in this visa bond. They had a lot of discretion. As I said, the $10,000 amount, that's the standard. The $5,000 amount, that will be for those who are unable to pay the $10,000. And the $15,000 is for applicants who will not be deterred by the $10,000 amount because of the nature and the extent of their contact in the U.S. Maybe if when you are applying, you indicated that you are going to visit somebody And it depends on who is giving you a letter of invitation. For example, if the person who is giving you a letter of invitation, if they believe that, oh, this person can easily forgo $10,000, then they will not accept for 10,000. They will increase the bond to $15,000. But again, this is going to be at the discretion of the consular officers. Now, these bonds must be paid online at pay.gov, regardless of the place where the application will be, where the application is being submitted or where the applicant is being interviewed. Now, the money will be held by the Department of the Treasury as an escrow style account under the DHS direction. DHS is Department of Homeland Security. Now, what's today's date? August 6th? Okay. Yeah, the pilot program begins from August 20, 2025, and it will last till August 5, 2026. When we say pilot program, it simply means that they want to use the program as a test case. It's going to be a test case scenario. So they want to start it and test it for 1 year, beginning August 20, 2025, and it will end on August 5, 2026, except maybe the data gathered from the operation, if they believe that the program works, then they can expand it. But right now, it is a test case. It's a pilot program. So it is only for 1 year. They want to see how it works before they determine how to proceed. Now, applicants who are subject to the bond will be issued an annotated single entry visa valid for only 90 days. So you can see, even paying the bond, 5,000, 10,000, or 15,000, it is only for 90-day visa. Can you imagine? Single entry, 90-day visa. Then CBP will admit them for a maximum of 30 days. So even if you have the 90-day visa, it doesn't mean you are going to be admitted to the US for 90 days. The maximum that you can be admitted into the US will only be 30 days, 1 month, even after posting the bond. They will only be able to enter the US through 3 designated ports of entries. You see, even after paying the bond, after getting the single entry visa, you can only enter the United States only through 3 airports, only 3 airports. So those 3 airports, they are Boston Logan International Airport, John F. Kennedy International Airport, and Washington Dulles International Airport. Those are the only 3 airports that you can enter the United States, even after paying the bond, after obtaining the single entry visa. You cannot come to the US through any other airport. For those, I don't even know how this will affect Nigerians who are flying Delta, because Delta enters the United States through Atlanta. But for this program, you cannot enter the United States through Atlanta. You have to enter only through any of these designated airports. I'm sure Delta Airline will have to adjust their operation if they still want to bring customers from Nigeria, because right now they're coming through Atlanta and New York. But this program, if you are going to post the bond, even after posting the bond, you get a single entry visa. You can only come in through JFK, Washington Dulles International Airport, and Boston Logan International Airport. Those are the only 3 airports where you can come in. Now, in addition, applicants will have to complete what will be called ICE Form I-352. Form I-352. ICE is Immigration and Customs Enforcement. ICE Form 312. The applicant will have to agree to the terms of the bond. Now, applicants should only post the bond after being directed to do so by a consular officer. This is not a bond you can post in advance. It's not that, oh, you schedule an appointment at the embassy for interview, then the next thing you go online to go and pay the bond. No, if you do that, you will lose your money. You will lose your money if you do that. So that is why it is important to listen to these instructions. The instruction says that applicants should only post the bond after being directed to do so by a consular officer. Applicant will be provided a direct link to make the payment by the consular officer. No refund will be given to any applicant who pays the fees without being directed to do so by a consular officer. So if you think, oh, I want to take a step ahead, I want to preempt them, I want to do this, maybe if I post the bond, maybe that will increase my chances of getting the visa. If you do that, you will lose your money. There will be no refund. So you have to attend the interview, and the consular officer has to determine how much bond you will post. And it is the consular officer who will send you a direct link where you will make the bond payment, even though it is going to be at pay.gov, but you have to get the link directly from the consular officer. Otherwise, you may not be able to get your money back. Now, payment of bond does not guarantee visa. You see, even if you pay the bond, the fact that the officer say, okay, go and pay the bond, and then you go ahead and pay the bond, that still does not guarantee that you will be granted visa. Even if you are granted visa and you pay the bond, that still does not guarantee admission into the US. That does not mean that the CBP officer cannot deny you admission into the US. Very important to be to please take note. Now, in addition, a visa bond will be returned to the applicant where a visa holder fulfills the condition of the visa as stated in the form I-352. Remember, I stated that before somebody can be admitted into the US, or even before you can enter the United States, you have to complete ICE form I-352, agreeing to the terms of the bond. So paying the bond is not sufficient. You have to agree to the terms and conditions of the bond. I will still give you the terms and conditions. As I said, a visa bond will be returned to the applicant when a visa holder fulfills the condition of the visa as stated in the form I-352 based on the information provided by DHS through the Arrival Departure Information System. Remember, okay, maybe I should go to the conditions first, the condition first of the bond. Now, no, let me just go in this order that I've planned to go. When a foreigner, a visitor, B1, B2 visitor, when they enter the United States, they pay the bond, they sign the form I-352 agreeing to the conditions of the bond, and as I stated before, the maximum period they can be given for the I-94 is maximum of 30 days. Now, if within the 30 days, you do whatever you told them you are coming to do, and then you depart, it is the DHS, the Department of Homeland Security, through the Arrival and Departure Information System. They will state all of these things there. So if you fulfill all the conditions, then you will be entitled to a refund of the bond. Now, your bond will only be returned on these conditions. Number one, applicant, you have to show that when you enter the US, you did not work without authorization and you departed the United States before the expiration of your I-94. So that is the first condition. You come to the United States, they gave you 30 days. Within the 30 days, you do whatever you told them you are going to do, and you left. You did not work without authorization. and you departed before your I-94 expires, that is the first condition for you to get a refund of your bond. The second condition is that if for any reason you need to apply for an extension or a change of status, you have to apply before the expiration of that 30 days. And of course, your application must comply with the new status, with your new status. And of course, you must also depart before the new I-94 expires. What that means is that if you come in and they gave you 30 days to stay, if for any reason 30 days is not sufficient to complete your purpose in the United States, you have to apply for an extension before that 30 days expires. Now, if that extension is granted, maybe they granted you an extension of additional 30 days. Whatever you came to the United States to do, you must do it before the expiration of the new 30 days. And of course, you must depart the United States before the expiration of the new 30 days in order for you to get a refund of this bond. The third condition is that if you post the bond and then you are granted the visa, but for some reasons you choose not to travel. I mean, there are some people who apply for visa and they were granted, but for some reasons they did not travel. I've seen people who were granted 2 years visa and they didn't use it within the 2 years. So if for any reason you are granted a visa, the 90-day visa, single entry 90-day visa, and then for some reasons you are unable to travel or you change your mind, you didn't travel, then you'll be, after the expiration of the visa, you'll be entitled to a refund of your bond, the bond amount, you'll be entitled to it. Now, another condition that can make you obtain a refund of your money is if the visa is denied after you have posted the bond. If you attended an interview, the consular officer asked you to pay the bond. After paying the bond, for some reason, they still deny you visa. So if your visa application is denied, you will still be entitled to the refund of your money. It's like I'm echoing.
That's what I
feel the echo.
because that's what I said last week.
Yeah, I feel the echo.
Is it that? Maybe it's too loud.
Hello?
No, it's still there.
No, it's better, but it's a little. Okay, yeah, I think it's better. Okay, I just want to be sure that our listeners they hear me clearly. So as I was saying, if after posting the bond, your visa application is still denied, then you'll be able to request a refund of your bond that was posted. Now, the last condition under which an applicant can get a refund is that if you are granted a visa, single entry 90-day visa, you posted the bond, you are requested to post the bond, and then you posted the bond. And then, like I said, the bond does not guarantee admission into the United States. You can still be denied entry by the CBP, Custom and Border Protection. So if this happens after posting the bond, if the CBP officer deny you admission, then when you return to your home country, you can request a refund of your bond. So those are the conditions for getting the bond back, the amount of the bond, getting it back. Now, sometimes after 30 days from your return, the bond may automatically be refunded to you. On the other hand, you can also manually request a refund of the bond, in which case you will need to schedule an appointment with a consular officer within 30 days of departure from the United States, and then you will show evidence of your departure to the consular officer, because sometimes it takes time for the I-94 arrival departure record to be updated, especially when it comes to departure. Remember that when people depart the United States, most of the time they don't go through immigration, they don't go through CBP officers. Most of the time they only go through the airline staff. So sometimes the airline agent may not update the system correctly. So sometimes you may have departed and the record may not show that you departed. So in such a situation, as soon as you get back to your home country, within 30 days, contact the embassy, schedule an appointment with the consular officer, show yourself, let them see you physically, show your passport, the biometric page of your passport for them to verify that you are actually back in your home country. So in such a situation, you can actually manually request the refund of your money. Another situation, if you obtain the single entry 90-day visa, and then maybe for some reason you are not able to travel within the 90 days, again, you can schedule an appointment with a consular officer and manually request a refund of your money. Because if you don't travel, there will be no record, there will be no arrival departure record, and of course, your money will just be hanging in there. The system will not automatically refund it. So you will have to manually request for a refund. Now, under these circumstances, applicant will forfeit their bond, in which case applicant will not be able to get a refund of this bond under the following circumstances. Number one, if an applicant violates his or her status. If you come to the United States, you tell them you are coming to attend a conference. Maybe the conference is going to be held in Atlanta on August 10. You ended up not going to Atlanta. Maybe you went to Colorado. You told them you are going to stay 30 days, or even you told them you are going to stay 2 weeks. You ended staying in Colorado for 3 months. Of course, that's going to be a violation of status, so you are not going to get the bond back. You are going to forfeit either the 5,000, 10,000, or 15,000, depending on the bond amount that the consular officer asks you to post. So you will lose the money in such a situation. The second condition under which the bond will be forfeited, if the applicant filed an unexcused or untimely change or extension of status. Now, this is very tricky. How do you determine what is unexcused? This is one area that is going to create a lot of problem for a lot of people, because this is like it's like an open check. It is too wide. How do you determine unexcused? For example, maybe you come for a business transaction. You are supposed to have a meeting on August 10. You got to the company, they told you, oh, sorry, the meeting has been rescheduled to September 5. So are you going to go back to your home country and then come back the following month, or are you going to wait? Now, if you decide to wait and you apply for an extension, will that be considered unexcused? So the issue is, how do you determine what is unexcused? This is going to be a dangerous portion of this policy, because who determines what is excused and what is unexcused? But again, I'm just stating what the current policy is as released by the Department of State. So if the applicant files an unexcused, untimely change or extension of status, the applicant will forfeit the bond amount. The next condition under which an applicant will forfeit the bond is if an applicant remains in the US beyond their I-94. So, as I stated, posting the bond does not even guarantee visa. If eventually you are granted visa, you will be granted single entry visa, and the visa will be valid for maximum of 90 days. When you come in, you can only come in through 3 airports. And then, even when you come in, you will be granted maximum of 30 days. If you now extend or stay beyond this 30 days, then you forfeit the bond. Now, the next condition under which you will forfeit the bond, if an applicant timely files a change or an extension of status, which is subsequently denied, and applicant failed to depart the US within 10 days after the denial, then that applicant will forfeit the bond. Now, as I stated before, immigration, the Department of State said that if an applicant file an unexcused or untimely change or an extension of status, but here they are also saying that even if you timely filed your change or an extension of status, but if that change or extension of status is denied, then you have to depart within 10 days. If you don't depart within 10 days, then you will still lose this bond. Again, this is really, really unfortunate, but here we are. Now, I know that some of the questions that people will have in mind is that which countries are affected by this bond issue. Now, according to the Department of State, they said that based on country overstay rate for fiscal year 2023, they have not released the number for fiscal year 2024, but based on fiscal year 2023, they are going to start with only 2 countries, and those 2 countries are Malawi and Zambia. They are going to start with those 2 countries. However, because this is a pilot program, they are going to be extending those countries. Any new country that will be included, they will give them 15 days notice. Right now, this pilot program is only going to start with Malawi and Zambia, and this is based on the overstay rate for fiscal year 2023. But new countries will be added as they continue to review the overstay rate from all these B1, B2 visitors. So I think we have a lot of questions already, and we have spent so much time on this, but it is important to provide all this information because these are changes that people need to know. As I said before, if you have an existing visa, either 2-year visa, 5-year visa, for as long as your visa is yet to expire, all this new rule does not affect you. However, that does not mean that you cannot be denied entry, even at the port of entry. But for new applicants, anyone that is just applying for B1, B2 visa, especially from these 2 countries, Malawi and Zambia, where the pilot program is starting from, at least as at today, those are the only 2 countries. But like I said, because this is a pilot program, so I know that from time to time, they are going to be reviewing it. But for any new country to be added, there will be 15 days notice. So it's not going to be sudden. Even though 15 days is still sudden, but at least there will be 15 days notice. So that is that. So let's go into the question.
That is so much money.
Yeah, especially if you have to, if the consular officer determines that you have to post $15,000, that's a lot of money just because we want to come and visit. I mean, it's really going to be, I don't know. How will you put down $10,000 because you want to go and visit a family? I mean, it doesn't make sense. Effectively, the Trump administration is trying to shut off people from not everybody, people from African countries. Because another thing that I didn't say about this program is that this program does not affect people from visa waiver countries. And come to think of it, look at visa waiver countries, European countries. Most European countries are visa waiver countries. So effectively, this program is targeted at Africans. It is targeted at third world countries because visa waiver countries are not affected. But anyway, let's go into the questions for the day. The first question here, hello sir, my US citizen son filed a concurrent I-130 and 485 petition for me and my wife back in 2022. Within 4 months, my wife had been given a green card while they called me for an interview. I had entered the US without inspection, but had since traveled out twice and paroled twice. I have recently renewed my 2-year EAD for a 5-year card. Recently, I got a notice via my online account that my interview has been cancelled. This is an interview I had attended back in August of 2023. Last week, I got a notice that my I-485 is being actively reviewed. This is an interview it's the same thing. Okay, this is an interview I had attended back in August of 2023. Last week, I got a notice that my I-485 is being actively reviewed. The online account status says step 4 decision. Is my IWI the problem? Sorry for the long story. May God reward and enrich you greatly for this free initiative of yours and bless your staff. Amen. Thank you. However, there is something that is not clear from this the question. Was the application filed after he has been paroled? That is key. And then secondly, what is the status of the petitioner? Is the petitioner, the child, is he a member of the U.S. military? Because if the parole, the reason I asked that is that if the parole was based on PIP, parole in place for active military members, and then the adjustment application was filed after the parole, you will still be able to adjust. Then secondly, even if the petitioner is not an active member of the military, if the parole does not have a limitation, you will still be able to adjust. However, it is not every parole that can lead to adjustment of status. So what I want you to do, go back to your parole document and look at it critically. If generally, parole will allow adjustment, but where there is an annotation in the parole that's not valid for adjustment, then you cannot adjust with the parole. So it is very important to determine whether your kind of parole can lead to adjustment or not. But more importantly, did you file the application after you were paroled, or did you file it before you were paroled? Because the law is that you cannot be eligible for a benefit after a subsequent event. You must be eligible at the time the application is filed. So if you are paroled and your parole does not have any annotation that says not valid for adjustment of status, then you will still be able to adjust your status. there should be no problem. But if the parole is annotated with not valid for adjustment, then you cannot adjust and the adjustment application may be denied. Next question, please. Afternoon, sir. For the I-94 expiration date on I-485, do you write expiration date for your approved H-1B visa if you change from B1, B2, or write the one given at the port of entry? No, you write the latest one. So if you change your status to H-1B and they give you a new I-94, it is the expiration of that new one that you will write in your adjustment application. Next question, please. Moderator, please, can you edit connecting by phone from the screen? Oh, you did already. Okay. Okay, that one has been dealt with. Okay. Good day, sir. Thank you for all you do. Sir, my friend had a green card interview 2 months ago, but it was cancelled when it was discovered that her husband was still in another marriage. Please move on. Now, she just received a 30 days removal notice this past Monday. However, she enrolled in a school before then to maintain her status. Should she be worried, and what should she do now? Also, she's been approved to apply for an I-140 through a company that wants to sponsor her. Can she still proceed with the I-140 despite the removal notice? What does the notice mean for her situation? Scroll back a little. No, let me start. Okay, because there are multiple questions, so that I don't forget. Let me start from the first question. My friend had a green card interview 2 months ago, but it was cancelled when it was discovered that her husband was still in another marriage. Okay, scroll up. That one does not have any question. Now she just received a 30-day removal notice this past Monday. However, she enrolled in a school before then to maintain her status. Well, the problem is when I-485 is filed, that is an immigrant petition. So whenever someone submits I-485 application, you are telling the U.S. government or you are telling the immigration that you want to remain permanently in the United States. On the other hand, the F1, is it F1? Scroll back a little. Did it change to F1? I didn't see F1 here. Okay, enroll in a school. Yeah, on the other hand, when it comes to F1, a student application, that is a non-immigrant visa. I-485 is an immigrant visa. Student status is a non-immigrant visa. The requirements are contradictory. They are opposite each other. When you apply for adjustment, you are telling the immigration that you want to remain permanently in the United States. When you apply for student visa, you are telling immigration that you want to be here temporarily and you intend to return to your home country at the end of your program. So naturally, anyone who has applied for an adjustment of status is not eligible for a non-immigrant visa. However, because non-immigrant visa is a discretionary type of application, so sometimes USCIS may use their discretion to approve it, and sometimes they can deny it on the ground that you have already shown immigrant intent. Despite all that, I don't know from this fact whether there was a gap between the expiration of the initial I-94 and the filing of the I-485. Was the I-485 filed before the expiration of the initial I-94? Like I said, even if the answer is yes, it still does not guarantee that the F1 will be approved because, like I said, F1 is a non-immigrant visa, which is discretionary, which shows that you intend to return to your own country, while I-485 is an immigrant visa, which tells them that you want to remain here permanently. So that is an immigrant intent. So that may lead to the issue of the student status being denied. Does she have reasons to worry? Yes, she has a lot of reasons to worry, because since it has been determined that the petitioner, the U.S. citizen spouse, has not terminated a prior marriage, that means the application, the I-130 petition, is not approvable, because under the U.S. law, it is bigamy for somebody to be married to more than one person at the same time. Even though this is not your fault, immigration may not use it against you, but the fact still remains that they cannot approve the petition filed on your behalf. And because the petition cannot be approved, when you get to removal proceedings, you will have to request a relief. You have to look for a relief that you may be eligible for, but certainly not this adjustment of status, because the I-130 cannot be approved based on the multiple marriages. That is the law. It's unfortunate, but that is the truth. And I think it also asked about another I-140 being filed. Okay, now, if there has not been a break in your status since you came in, like I said, if you file the I-485 before the expiration of the initial I-94, then if this I-140 is a concurrent one, you may have a relief. But if it is not a concurrent one, even if you have an approved I-140, it will not solve the problem. Because the problem with most I-140 right now, it is only EB1 that visa is current. So I-140 does not keep somebody in legal status. It is the I-485 that keep people in legal status. So even if you have an approved I-140, that is just a petition. That does not keep you in legal status. So even if an employer filed I-140 on your behalf and the I-140 is approved, it still does not keep you in legal status. What keeps you in legal status is either unexpired I-94 or adjustment of status I-485 that was filed before the expiration of your I-94, if you are looking at employment-based. So you are really not in a very good shape right now. But at the same time, go back and look at your I-94. If the initial 485 was filed before the expiration of the I-94, and then if the new I-140, if you are able to file it concurrently with I-485, you may still be in status. But if you are not able to file it concurrently, because I-140 does not keep you in status, you will still face some challenges at the immigration court. Next question, please. Good day, doctor. I submitted my EB2NIW petition approximately 18 months ago, but I'm yet to receive any adjudication feedback from USCIS. I've been checking processing regularly, but it kept changing. Please move it forward. That's it. Well, not a whole lot we can do about this one, because processing time is a major challenge. I mean, if the application or petition is still within processing time, then all you can do is to wait, because they will not even allow you to submit a service request if it is still within processing time. So you just have to wait.
Okay, remember this person here? This one? About the parole?
Yes, yes.
Okay, so they sent the parole. She said, the petitioner is not a military personnel, just a U.S. citizen. The parole says AOS, the petition was filed after the parole.
Okay, the parole says AOS.
AOS.
Yeah, then there's nothing to worry about. It means that you can adjust safely. There's nothing to worry about. Yeah, that's a good one. But where the parole says not valid for adjustment, that is when there can be problem. But because it says AOS, AOS means adjustment of status. So that's not a problem. You'll be fine. Okay, the next one. Good day, sir. My green card wife filed I-140 on my behalf. Date of filing on the current bulletin for F2A is, what did I say?
I-140.
Oh, sorry. Good day, sir. My green card wife filed I-130 on my behalf. Date of filing on the current bulletin for F2A is 4/1/25. If next bulletin moves to May 1 and my priority date is 5/3, do I have to wait another month? Oh yes, you have to wait. You cannot apply for adjustment until your priority date is current. Yes, if your priority date is 5/3, if it moves to 5/1, you still cannot file. But I also have to let you know that if your wife, as stated in this question, if your wife is a green card holder, for you to submit I-485 adjustment application, you will have to be maintaining legal status. So if you are out of status, your green card application is going to be denied and you are going to be placed in removal proceedings. So you have to ensure that you are maintaining legal status. Otherwise, it is better for you to wait until your wife becomes a U.S. citizen before you apply for adjustment. One of the major differences between a U.S. citizen and a permanent resident is that U.S. citizen can petition for immediate family members who are already out of status. On the other hand, a permanent resident cannot petition for immediate family members who are out of status. A permanent resident cannot petition for parents. U.S. citizen can petition for parents. A permanent resident cannot petition for fiancé. U.S. citizen can petition for fiancé. A permanent resident cannot petition for siblings. U.S. citizen can petition for siblings. A permanent resident cannot petition for married children. U.S. citizen can petition for married children. So these are some of the major differences between a green card holder and a U.S. citizen. So one, you have to wait until the visa bulletin gets to your own turn. Second, you have to be maintaining legal status as at the day you submit your adjustment application. Next question, please. Sir, what options are available for my daughter that I used in my asylum case, which is still pending in immigration court? Since my daughter has turned 18 years old, is it possible for her to file her own claim based on the, move it forward, please, based on the initially filed? Well, the cutoff is not 18, so there's nothing to worry about yet. The cutoff is 21, not 18. So your daughter is fine. The cutoff date is 21 years old. So you still have about 3 more years to go. Next question, please. Good day, sir. I applied for public health benefit in the past, but never used it. Will this affect my EB3 petition? Thank you. Well, EB3 is not the issue. The issue is the adjustment application. It is the adjustment application. And again, I don't know on what basis you apply for the benefit, for as long as you did not lie in your application for benefit. For example, some people apply for benefit claiming to be a U.S. citizen. If immigration found out, that one is a major problem. Unfortunately, there is no waiver for false claim to U.S. citizen. So that may be a problem. However, that in it, the fact that you apply in itself is not the problem, because in the past, in applying for adjustment of status, emergency medical needs are exempt from disqualification, from grounds of inadmissibility, emergency medical needs. So if you apply based on emergency medical needs, then there is no problem. Or if you have a valid maybe non-immigrant status and you applied, there is no problem. For example, let's say somebody on H1B or somebody on R1 or somebody on F1, maybe your wife or even you as a woman was pregnant and you needed to have a baby at the hospital and you apply. If you are giving emergency Medicare services, those are not grounds for denials. Those are not problem. You'll be okay. But if you apply falsely claiming to be a U.S. citizen when you are not, then that may be problematic. Next question, please. Good day, doctor. Thanks for all you and your team do. May God continue to bless you all. Amen. I got the name of the airport I came in through in Chicago the first time I came to this country. Please, how can I access my I-94 info? Oh, if you want to access your I-94, that does not even have anything to do with your airport. Just go online, cbp.gov, and then, or the easiest way, if you don't know how to navigate all these government websites, you can just go on Google and type request most recent I-94. So it will show that CBP website. So just click on it. It will ask you, it will warn you that you are entering a government website and that you accept the liabilities and all of that. You click OK. After that, it will ask for your name, your date of birth, your passport number, country of issue of your passport, country of citizenship. Once you provide all those information, it will give you your I-94. So you don't even need the airport where you came in. It's something you can easily get. And I don't know if you can please post that link in the description. Okay. We will post the link in the description so that you just click on the link and it will take you to the website where you can put in your information and get a copy of your I-94. The next question. I have EAD card, also a pending 485 application for green card. My question, will I be deported if ICE accost me? No, if ICE accost you, you show them your I-485 receipt notice. That is a valid status for as long as it is pending. Unless it is denied, you are actually in valid status. So if you are encountered by ICE, just make a copy of the receipt notice of the I-485 and keep it in your wallet, so that if they accompany you or if they accost you, just show it to them, or even a copy of your EAD. Your EAD will have your alien number. So with a CBP officer, they can easily pull your alien number and assess your case, so they will know that you are maintaining legal status. But more importantly, and the most safest thing to do, keep a copy of the I-485 receipt notice with you. You will be okay. So there is no cause for alarm. Next question, please. Good afternoon, doctor. I filed for, in 2021, my previous, did I miss something? What I filed for what? There's nothing there. I don't know what this person filed, but let me keep reading. Okay. I filed for DASH in 2021. My previous biometric was reused. VAWA approved in July 2024. I submitted medical in February 10th. I was scheduled for biometrics again in June. Is this okay? 42 days after biometric and no decision. Well, there's nothing out of the ordinary in this. Sometimes biometrics can be recalled for several reasons. It may be that the biometrics is not clear enough. It may be that maybe the picture was not clear, or maybe the biometrics was not clear, or maybe there were some discrepancies. Scientifically, it is stated that two people cannot have the same biometrics, but sometimes it does happen. We've seen it happen before, where the one person will submit a biometric and it will match another person's biometric. But guess what? Upon investigation, most of the time, in fact, 100% of the time, it will turn out that this person, the biometric belong to the same individual, but maybe this person has used a different name which they didn't disclose, and then they found out. Of course, things happen. I've seen that happen before, but again, there are so many reasons that could lead to a new request for biometrics. Doing biometric multiple times does not indicate any problem. It is normal. It is something that do happen. Next question, please. Good afternoon, doctor. Please, what does initial evidence mean in I-130 and I-485? It simply means that you didn't submit the required documentation that are supposed to go with the application. You know that this does not mean that they have started working on your application, but they are just looking at the prima facie document. For example, if you are applying for adjustment of status and you didn't provide your birth certificate, that will be initial evidence, because everybody applying for adjustment of status must show birth certificate as proof of identity. So if you don't submit something as simple as that, they will issue request for initial evidence. Secondly, another thing that could indicate initial evidence, if you are submitting a family-based adjustment of status and the affidavit of support, maybe your sponsor's income is not sufficient. These are initial evidence. Or maybe you are using a joint sponsor and you didn't provide a tax return, or you provided a tax return, you didn't provide recent pay slips. All these are initial evidence. It simply means that the documentation that are supposed to go with the application initially, those things were not present. So that is what it means. So it's not a big deal. So just respond to it and they will continue processing your application. Next question. Is there a way I can check my asylum status, or probably when I will be called for hearing? Well, if this person is talking about hearing, so that's assuming that this person is in removal proceedings. If you are in removal proceedings, then you should have a hearing notice already. But if you don't have a hearing notice, just go to EOIR case status check. You can go to Google and type EOIR case status check. So the website EOIR will pop up. You click on it, you put in your alien number, then it will give you information about your hearing. It will tell you the date when your case is pending. It will tell you whether it's a master hearing or individual hearing. It will tell you which court, and it will tell you the name of the judge as well as the date and time of the hearing. It will also tell you whether it's a master or individual. Next question, please.
In person or WebEx?
Yeah. It will also tell you whether the hearing is in person or it is WebEx. Next question. Good afternoon, doctor. I'm a LPR, legal permanent resident. Can I petition for my daughter who is 20 years old now and lives in Nigeria? Also, will I save to travel to Nigeria for 4 months? I have no criminal record. Yes to both questions. You can petition for your daughter who is 20 years old as a permanent resident. Yes, you can petition right now, and then you can also travel to Nigeria for up to 4 months without any problem. I don't see any problem. As for petitioning for your daughter, submit the petition as quickly as possible and continue to check the priority date. If the priority date becomes current before your daughter turns 21, then your daughter will be covered by what is called Child Status Protection Act. But if the priority date is not current before your daughter turns 21, then the category will change from F2A to F2B. Now it will be unmarried children of permanent residents. Next question, please. Hello, Dr. Olu. Any advice for someone with pending U visa who has an EAD from deferred action from Biden's is it bona fide? Okay, from Biden's bona fide determination executive order, but also has a final order of removal. Well, the final order of removal can be problematic. I will advise you, maybe you file a motion to reopen with your U visa, since you already have a prima facie determination with your U visa. So maybe you should file a motion to reopen. But again, to be honest with you, based on this fact, I don't know any other thing apart from this fact that you are providing. Based on this fact, I will not do anything right now. Just lay low until the U visa is approved. Because the fact that you have a U visa pending does not automatically mean that the U visa is going to be approved. So I will lay low until the U visa is approved. As soon as the U visa is approved, then go ahead and file a motion to reopen with the immigration court. That would be my suggestion. Okay, still checking with ICE regularly. Are they being detained now at the check-in? Just go with the receipt notice for your U visa. I do know that even under the current administration, they still have some soft spot for victims of humanitarian applications like VAWA and U visa. So go to your appointment, your check-in, with a copy of your U visa receipt notice, so that at least they will know that you have a pending U visa application. That would be my advice. Next question, please. What processing time I-601 waiver for inadmissible after you done interview last year? Okay, I'm assuming that this person is applying for the I-601 in the US, because it is not really clear whether this interview is USCIS interview or consular interview. Because generally, I-601 waiver, if you are talking about consular interview, it should have been approved before you even proceed with the consular processing. Normally, once an I-601 is filed, you notify the National Visa Center that you have a pending I-601. On the other hand, if this person is in the US and you have a pending adjustment application and then you file I-601, then it is likely, more likely than not, it is the same officer who conducted the interview that will adjudicate the I-601. So you have to wait, give them a patience. I-601 is one of those applications that I will not advise anyone to put pressure, because it's a discretionary application. You put too much pressure, they can deny it, and there's nothing you can do. It's something that is discretionary. So for that reason, I will advise you to exercise some patience. Wait for them to take their time, because you don't want to do anything that will be on the wrong side of the officer who is adjudicating it. Just be patient. Next question, please. Thank you, sir, for all you do for humanity. You're welcome. My question is this. I'm planning to travel to Nigeria this August for 6 weeks on my advanced travel parole because my I-485 application. Please move it. Is still pending. Given the uncertainties surrounding the parole and a possible travel ban, is it wise for me to continue this trip sincerely. Well, first and foremost, the travel ban does not affect somebody who is in the US and is applying for adjustment of status. The travel ban does not even affect people who have existing visa. It is new applicant, people who are trying to renew their visa, either by Dropbox or first-time applicant. Those are the people who are affected by the travel ban. Secondly, to determine whether the advanced parole is safe to use or not, the first question is, how were you in status at the time you apply for adjustment? Did you enter the US legally? If the answer is yes, were you in status at the time you apply for advanced parole? Do you have any criminal record? These are the things that can affect the re-entry when you use advanced parole. But if you do not have any criminal record, if you did not if you are still in status at the time you apply for adjustment of status, then there is really nothing to fear. And of course, I don't even know what the adjustment is based. Is this a family based? Is this employment based? If it is employment based, then it may be dangerous to travel if you are out of status before you apply for the adjustment. Because if the adjustment application is denied while you are abroad, it may be difficult for you to come back. But if this is a family petition, it is a little different. The question is, do you have criminal record? Did you apply when you are still maintaining legal status? If the answers are positive, then there is nothing to worry about. I mean, I have clients who uses advanced parole all the time. I mean, I just came back from a trip and I met people who used their advanced parole at the airport, and there was no problem. But there must be no criminal record, and you have to also be sure that if this is employment based, you must be maintaining legal status. Next question, please. God bless you, sir. I applied for EAD and advanced parole combo on December 2024. My EAD is approved. Advanced parole is not approved yet. Please advise. Well, you still have to wait. Immigration is not consistent when it comes to this issue of advanced combo, advanced parole, and EAD. They are not consistent. And the truth of the matter is, even as an immigration attorney, I still cannot tell you accurately what criteria immigration is using, because we have applied for people combo and then they approve it and they give them combo. We have applied for people combo. Yes, they approve only employment authorization. They did not process the travel permit together. Subsequently, they approve them separately. So I really don't know. I think there is inconsistency on the part of USCIS regarding this. But it is not unusual. You will still get the travel permit. It will just come in paper form and not a combo card. I really don't know what criteria. There was a time, I think in 2002, when they notified us that they were going to stop the combo card and then process it separately. But even after that, we continue to get combo cards. So we really don't know what criteria. Like I said, I can't tell you authoritatively what conditions can lead to combo card or separate one. But either combo or separate, the fact remains that once it is approved, both of them are valid. Next question, please. Good day, Dr. Asekun. Kindly advise her on how to go about our case. We had filed for 4 years now, and the last time we heard from USCIS was in August 2023, when they acknowledged receiving, please move forward, receiving our medical record, marriage-based. They said they have filed for 4 years. Well, I know that in some service centers like the National Benefit Center, the processing time, the last time we checked, I think it was 52 months.
52.5.
Okay, 52.5 months. Yeah, that's actually more than 4 years because 4 years is 48 months. So I'm going to advise you look at the receipt notice, go online and check the processing time. If you don't know how to do it, you can go through our website, oluasekun.lawyer, click on resources, click on check the status of your case, scroll up and then click on processing time. It will ask you what kind of application. So if your I-130 is still pending, choose the I-130. If your I-130 has been approved and you are waiting for the 485, choose the 485. And then it will ask you which office it is pending. Look at the receipt notice and select the office. But like I said, National Benefit Center, honestly, I have no idea what they are doing in that office. 52.5 months. I don't know what they are processing, but check it. If it is not at the National Benefit Center or if the processing time has elapsed, you have three options. You can submit a service request that this case is outside normal processing time. Your U.S. citizen spouse can also use what we call congressional intervention. That simply means let him or her go and talk to the congressman in your district and seek congressional help. Like I said, this is something that we have seen work over and over and over again. It does work. But if eventually it failed, if this is beyond processing time and you know that you do not have any skeleton, because he who lives in a glass house does not throw stone. If you know that you do not have any skeleton, then go ahead and file mandamus. Your U.S. citizen spouse has a right as a U.S. citizen to file mandamus to demand adjudication of the case. So those are the three options. Next question, please.
Okay, people are saying they can hear you very well. That's all.
Okay, hello, sir. I entered the USA through the border with parole and admission DT in my I-94 and I married a US citizen. Can I adjust my status? I think I answered this question from somebody who asked parole question. So you have to look at your advanced parole. So if your advanced parole does not say it's not valid for adjustment, then you can adjust based on marriage to a US citizen. However, if your advanced parole indicates that it is not valid for adjustment, then you cannot adjust. You may have to do consular processing. So consular processing means that your spouse will have to file I-130 on your behalf. Once the I-130 is approved, the case is forwarded to the NVC. You notify the NVC that you want to apply for unlawful presence waiver. So you will file I-601A. If that one is adjudicated, then you continue with the processing with the National Visa Center. Once they finish processing and they forward your case to the embassy for interview, then you travel back home and attend the interview. To be honest with you, I'm being honest, brutally honest. Under this administration, I'm not even sure if I will take that risk because I've seen the U.S. Embassy under this administration deny a legitimate immigrant visa petition. And when I say legitimate, I mean legitimate. Nothing, no skeleton, nothing, clean. In fact, nothing could be cleaner, and yet the embassy denied it out of ignorance. I don't know whether the consular officer didn't understand his or her job. Or I can't figure it out. This was based on investment. Somebody who invested a huge amount of money in the United States and filed a petition based on that investment. The petition was approved. The person came to the US on a visiting visa while in the US, found out that the petition was approved and then applied for adjustment of status. The green card was approved. We now file IA-24 to do follow to join for his wife to join him. We process it, everything was approved. The wife appeared at the embassy only for the consular officer to say that, oh, you are not even the applicant, you are not eligible, and then they deny it. I have no explanation. I have no idea why. I mean, this is the height of incompetence. That's the only thing I will say. But of course, the petition has to be returned to USCIS and then we'll take it from there. But I'm just telling you that under this administration, is either they have incompetent people working at the embassy or people who are doing this intentionally. I mean, how else can somebody show ignorance other than that type of denial? So if I'm in your shoes, honestly, I will not go out under this administration right now. Next question, please. Good day, sir. If someone had a citation ticket for driving while unlicensed, paid the fine, it is okay to travel abroad. The incident happened when the person had no legal maybe status then, but now had green card. Please move on. Oh, there's no problem with that. I mean, there's no problem with that. Citation is not an issue. Yeah, the person can travel. They may not even have record of that because citation does not really involve biometrics or anything. But even if it does, this is not one of those grounds of inadmissibility. There's no problem. You can use your green card. The next question. Good day, attorney. God bless you and your team for the good work you are doing. Amen. I applied for asylum within 1 year of my legal entry since 2021. My sister and mother are both citizens. Please move it forward. My sister said it will take long for her to file for me. Can my mother file for me? Secondly, please tell me how H-1B visa works. My son just won H-1B visa after his 2-year post-graduation. Thank you for confirming.
No, that's from us.
Oh, okay.
Yeah, just graduation.
Okay, first and foremost, let me explain something. The way immigration law, the United States immigration law, defines family is different from the way English dictionary defines family. Under English dictionary, anyone who is your parent, your siblings, your children, they are all family. However, it is not the same under immigration law, U.S. immigration law. Under the U.S. immigration law, family of a U.S. citizen only includes the parents, the spouse, and minor children under 21. Anything above that constitute extended family. Now, based on the fact that you provided, you are not the U.S. citizen. Your mom is the U.S. citizen. So because you are over 21, you are not part of your mom's immediate family. Secondly, your sister is a U.S. citizen. Because you are not part of her immediate family, because you are not your sister's spouse, you are not your sister's minor children, you are not part of her immediate family. Why is this distinction important? It is important because immediate family of a U.S. citizen, they are the only one who can benefit for immediate adjudication of a petition. So that means that visa bulletin will not matter. That means that you do not need to wait for any priority date. On the other hand, for extended family members, you will need to wait for visa bulletin because for extended family members, there are numerical limits to the number of applications that immigration can accept or approve annually. So for siblings of a US citizen, for the entire world, United States Citizenship and Immigration Services can only process 65,000 applications annually for the entire world. And I don't need to tell you that they probably have millions of applications pending. So because of that, the waiting time right now, as at the last time I checked, the waiting time is about 16 years before a sibling, before you can benefit from a petition filed by a sibling. On the other hand, for a US citizen parent, a lot of factors, multiple factors will determine how long you have to wait. One of the factors is whether you are married or not. If you are married, then it is going to be a longer wait. Please, can you help me check the processing time for F3, married children of US citizens, and F1, unmarried children of US citizens? If you are not married, you still have to wait, but the waiting time will be different from people who are married. So we are just trying to check the waiting time. So once we have that information, I will pass it across. But right now, either of them can file a petition on your behalf, but that petition will not keep you in status. In actual fact, the petition by your mom will probably be faster, but again, it will not keep you in status. They will only be able to submit I-130 petition on your behalf. That will not keep you in status. Secondly, what's the...
So, okay, at the National Benefit Center, it's 56 months for...
No, not that. I mean the visa bulletin. Yeah, the visa bulletin.
Okay, hold on, sorry.
Yeah. Now, while waiting for the information about visa bulletin, let's talk about the H-1B. You indicated that your son got H-1B visa. Tell me how H-1B visa. My son just got visa. Yeah, H-1B is a temporary employment visa. If it is approved, it will give your son the opportunity to work for the employer for a period of 3 years. Now, before the expiration of the 3 years, if the employer is satisfied with his work, the employer can extend the 3 years by another 3 years, making a maximum of 6 years. In the meantime, after your son starts working for the employer, if they are satisfied with his job, they can commence the process that is known as labor certification, PAM, permanent labor certification, on behalf of your son. That will require the employer to post the position in a major newspaper in the area of intended employment, post the position with the state workforce agency, advertise the position in at least 3 online job search websites, place the position, advertise it on the employer's website if they have any, and then place a notice of job offer at the employer's principal place of business. After doing all of this, if there are no American citizens who are interested or willing to do the job, then the employer will apply to the Department of Labor and submit an application for labor certification. If the application is approved, then the employer can submit Form I-140, Immigrant Petition for Alien Worker, on behalf of your son. So H-1B is a temporary employment visa. It is valid for 3 years. It is renewable for another 3 years, making a maximum of 6 years, and the employer can actually make it permanent if they offer the position to American citizens and none is available.
Okay, so F4?
No, F3.
Oh.
No, F4, I already said that was more than 16 years. Yeah.
Okay.
F1 and F3.
F1, is it in the
Well,
saying
it doesn't really matter.
Okay, I'll
Just
do
give the
it.
two figures.
Okay, so F1 is July of 2016.
July 2016. That is unmarried children of a U.S. citizen. This is 2025. So if they are processing July 2016, that means the waiting period is 9 years. 9 years for unmarried children of a U.S. citizen. What about F3? Married children of U.S. citizens.
Is August of 2011.
August of 2011. That is about 15 years, I think. Yeah, that's about
14.
2011. Yeah, that is 14 years waiting. Again, confirm the F4 again. I know that the last time I checked it was about 16 years.
Yeah, it's January of 2008.
That's even more than 2008, January 2008. That is for siblings, F4. So 2008, huh?
That's 17.
That's 17 years. So the waiting period is 17 years. Okay, next question, please. Greetings, sir. What is the fate of someone who is given the option of a fine or appeal to be done within 15 days? In connection with what? What is this question?
Last week, sir, can someone travel? Which, the greeting, sir, what's the.
No, the question I just read, you move. It says, what is the option? Or is it a continuation?
No, what is the fate of someone who's given the option of a fine or appeal to be done within 15 days?
Yeah, I don't understand the question.
So, in connection with what? Well, if the person who asked this question is online, you can explain it. I don't understand. The question says, what is the fate of someone who is given the option of a fine or appeal to be done within 15 days?
And what
In connection with what?
and what would give you the option of a fine or an appeal?
Is this talking about a criminal case?
I have no idea because that doesn't make any sense.
Oh, or is this the same? Can you check who sent this question? Maybe it's the same person who asked question about a
It was
ticket.
from last week.
Oh, okay.
Yeah, it was
Well, if the person is online, you can clarify the question. I have no idea what you are talking about. So, option of fine in connection with what? Is it in connection with a pending application? Is it in connection with what? So I don't know in what context the question, so I don't even know how to answer it. Okay. Next question. Can someone travel on OPT? The answer is yes, but it is risky, especially under this administration, because for you to be on OPT, that means you have completed your program. So you are now at the mercy of the CBP officer. So you can travel on OPT, and then they can deny you entry upon your return. I've seen it happen under this new administration. So I will not advise it. Is it possible? Yes, it is. Is it safe? It's not guaranteed. Next question.
That's our last question.
Okay, the one I read. Okay. Yeah, I even realized that we've been online for more than 1.5 hours. Okay. Well, we will have to be ending today's edition of our podcast at this junction. Again, remember to invite your family, friends, and colleagues. Let them join this podcast where we provide useful information every week, every Wednesday, 12 p.m. Central Standard Time. And that is 11. No, that is 1 p.m. Eastern. Currently, that is 6 p.m. Nigerian time. That is 10 a.m. Pacific. And that is 11 a.m. Mountain time. Okay. So, we hope to see you again next week. Until then, stay safe and be careful. God bless you.